I'm going to introduce our topic today. Debtors' prisons were outlawed in the United States 200 years ago. In 1983, the United States Supreme Court ruled that it was unlawful for defendants to go to jail because they are too poor to pay their court fines, and that a judge must consider whether the defendant has the ability to pay or is willfully refusing. In May of this year, National Public Radio featured the results of a year-long investigation into modern-day versions of the debtors' prison. The investigation included 150 interviews with lawyers, judges, offenders in and out of jail, government officials, advocates, and other experts. Among its findings was that since 2010, 48 states have increased criminal and civil court fees. Benton County was featured as an example of a system that heavily utilizes the pay or serve mechanism most extensively. According to their findings, over a 4-month period in 2013, on a typical day, a quarter of the people who were in jail in Benton County for misdemeanor offenses were there because they had failed to pay their court fines and fees. To discuss the issue of financial legal obligations or the pay to serve and the poor who sit out their fines in jail, we are fortunate to have an expert speaker with us. D. Willis has lived in this community for 26 years. He worked as a budget and financial analyst for the federal government and retired from the U.S. Department of Energy in 2002. He worked as an organizational consultant from 2002 to 2006, and then was a chaplain supervisor at the Tri-Cities Chaplaincy until 2009. He has worked as a corrections chaplain at Benton County Jail since then, and is a licensed chemical dependency counselor at Lourdes Counseling Center in Richland. Dee holds master's degrees in public policy and applied behavioral sciences. He earned a certificate in chemical dependency treatment from Columbia Basin College in 2002. The Badger Club values fairness, civility, and an honest consideration of contentious subjects. To this end, typically, the Badger Club prefers to have two strong presenters offering differing perspectives on the topic being presented. In this case, no one we ask to present a supportive view of financial legal obligations, otherwise known as the pay or serve mechanism, would agree to appear, even though judges in this county use this instrument on a daily basis. Thus, we lack an affirmative representative from the side that supports the use of financial legal obligations for dependents of criminal and civil violations. To his credit, Mr. Willis agreed to present the concerns about this system as it occurs in Benton County. I know that Dee would have preferred to have an opponent against whom his ideas would have found some traction. Instead, he is one voice that we hope can find a fair hearing in this forum of public opinion. Please welcome with me Mr. D. Willis.
Thanks, Tom. Okay, I'm nervous. I'm going to do this. I want to thank my colleagues and supervisors at the Benton County Jail, all the way up to the undersheriff and the sheriff. They have been my colleague, they've been supportive, and I appreciate them there. I think the people of Benton County at the jail get at least as good as they pay for. My good friends, people who know me best will tell you that I'm not good at argument and debate. My wife wins every time. And I want to thank Judge Ingvalson for not being here next to me today to test my skills. I have a question for you too about format. I could stop at various points in my talk and express what I think would be the court's objections to what I'm saying, if you would like for me to do that. Okay?
Yes.
All right. So I will do that. So that'll make my talk more disjointed, but it'll be a good excuse if I don't do well. The father of Charles Dickens, that great English novelist of the 19th century, his father was imprisoned for debt in 1824 in the Marshalsea prison in London. Can everybody hear me? Okay. Dickens at that time was 12. His shame and sense of abandonment were profound. He never got over the experience of his father's imprisonment for debt. Dickens wrote about debtors' prisons in at least 3 of his novels, David Copperfield, Pickwick Papers, and Little Dorrit. He also wrote at the end of his life about debtors' prisons too, in his memoirs. He said, "My whole nature was so penetrated with grief and humiliation that even now, famous and caressed and happy, I often forget in my dreams that I have a dear wife and children, even that I am now a man. And I wander desolately back to that time of my life." So here we are, 2 centuries later, in a supposedly more enlightened time in a far richer nation than Dickens's 19th century England. But there's little to distinguish Dickens's experience and the experience of thousands of people in Benton County here 200 years later with our own 21st century debtors prison. I first learned of the Benton County debtors prison phenomenon when an inmate who had been transported at great expense, by the way, by our county, from Tacoma to sit out fines for debt. He told me about it in 2010. I didn't believe him. But I started looking into it at that point and found that he was right. The more I learned about it, the more appalled I was. Every day, today, there are about 100 people, about 20% of the county inmates in the jail, who are there simply because they have failed to pay their fines, fees, and court costs. Mr. Willis, you're exaggerating. These 100 people have mostly committed no new crimes. There are another 20 or 30 who are there to sit out fines who also have committed new crimes. Sometimes these 100 people have new technical charges associated with failure to pay fines. Both Benton courts do this. They do it in different ways that I'll talk about shortly. They are the only 2 courts in the state of Washington who jail people in great numbers for failure to pay fines. And when I say fines, I mean the whole suite, the costs and the fees. So I want to take a step back for a minute and talk about the 2 Benton County courts, just to give you some basis for further discussion. District court hears mostly misdemeanor cases in traffic infractions, the less serious crimes. District court's defendants usually first serve a sentence for their crime, trespassing, disturbing the peace, so forth. And then, if their fines remain unpaid after a couple of months, they sit those out. That's the term of art we use in the criminal justice system, sitting out fines in jail Their balances in district court are reduced, their fines balances are reduced by $50 a day while they're incarcerated, and they're released when no balance remains. So let me add this. A couple of the judges in district court routinely add punitive time to the sentences people serve for unpaid fines. The time that people under the jurisdiction of district court serve for unpaid fines often exceeds the jail time for their original crime. Benton County Superior Court hears mostly felony cases, more serious crimes. Superior Court defendants ordinarily serve a sentence in prison or jail for crimes against people, crimes against property, or for drug crimes. These defendants' fines are usually higher than those in district court and are almost always supplemented by a long list of fees and costs. I have that list. Some of these fees are mandatory, required by law. A few of them are. Most are not. Most are discretionary. Our Superior Court charges the entire list of fees, mandatory or discretionary, to defendants. In addition, defendants pay 12% interest on their fines balances and have more fees and costs added annually. Superior Court defendants who have not made payments can sit in jail for up to 60 days per failure to pay charge, again and again. Their fines, Superior Court defendants' fines, do not diminish with time. In fact, they increase. Felony fines often amount to tens of thousands of dollars and are a lifetime sentence if you're poor. They don't go away. So the term for poor in the criminal justice system is called indigent. So I'll be using that term as well. And Webster defines indigent as one who suffers from extreme poverty. So ladies and gentlemen, there are three thoughts about the Benton County Debtors Prison I want you to take home with you. Three. First, Debtors Prison affects mostly the county's poor and serves to keep them poor. Two, Debtors Prison violates the rights of defendants. Three, Debtors Prison is a bad financial deal for me, for Benton's property owners. So I'll say more about each point. Number one, Debtors Prison affects mostly the poor, people living below the federal poverty level. This is objectively true. In 2012, almost 70% of district court defendants had so little money that the court had to appoint attorneys for them. In Superior Court, that figure was closer to 80%. These people are frequently homeless, addicted to substances, mentally ill, parents caring for small children, and physically or learning disabled. These people are the prostitutes and tax collectors who Jesus loved. These people are his crippled, lame, and blind. Neither court makes any effort to set fines amounts and payments in a way that reflects these defendants' ability to pay them. So it's fair to say that Debtors Prison punishes people both for their crime and also for their poverty. So in response to my assertion that Debtors Prison affects mostly the poor, here's what I've heard people from the court say at various times. And I'm not going to try to rebut. I'm just telling you. It's just not true. These people have money. They have cell phones. They dress nicely. Another one. We don't charge interest. We're the best collection agency in town. Another one. If we send fines to collection instead of jailing people, they'll owe even more. Another one. These people are career criminals. They need to be jailed. Number 2, debtors prison in Benton violates defendants' rights. Now, this is kind of dense. It's legal stuff. I got it from the Washington State Supreme Court. I have a few copies. Lots of case law at the federal and state level has established 4 points about people who owe fines. A, courts may not jail defendants for non-payment of fines and court costs when failure to pay is solely because of indigence. I'm going to read that again because this is key. Courts may not jail defendants for non-payment of fines and court costs when failure to pay is solely because of indigence. B, before jailing a person for failure to pay, a judge must inquire into a defendant's ability to pay. C, courts must find that a defendant has willfully refused to pay when she has the means to pay. D, courts must provide defendants with appointed counsel in a meaningful way before incarceration for failure to pay. So let's address each of these 4 points, these legal requirements as they relate to Benton. With regard to the prohibition of incarcerating people for failure to pay solely because they're indigent, Benton incarcerates people for failure to pay solely because they are indigent on a grand scale. That's clear to me, it's clear to other observers. We're holding people accountable. Incarcerating them ensures compliance with court orders. Second, with regard to the requirement to inquire about a person's ability to pay, district court hardly does it at all. Superior Court doesn't do it in a meaningful way. The Superior Court's clerks have a form. The judges don't appear to read that form. The form invites people to sign away their rights to an attorney. And just about everyone, I've never heard of any exceptions, is expected to pay $25 a month, sometimes $15 a month for every charge, for every felony charge. C, with regard to the requirement to find defendants in willful refusal to pay, neither court can do that because neither court has standards for determining willful refusal. The court's decisions to jail someone for failure to pay turn more on how many payments defendants have missed. That's their implicit definition of willful refusal, rather than on their financial circumstances and their inability or ability to pay. D, with regard to the requirement to provide counsel, the county, Benton County, takes away court-appointed attorneys after a defendant is found guilty of their crime. Defendants have no counsel as they fight a losing battle with their fines payments. In district court, people get to see a lawyer at the very end at what I call cattle call, when people by the dozen are brought in and arraigned when it's too late. In Superior Court, as defendants are about to be put in jail for non-payment, judges will sometimes ask if the defendants want to talk to an attorney. But defendants in either court are rarely told they have a right to talk to an attorney before being jailed for non-payment. If the courts were to take all the necessary steps they should take to observe defendants' rights and do that meaningfully, not just as a fig leaf, the court's cattle herding approach to jailing people for non-payment of fines would come to a screeching halt. We give people lots of chances. They just don't cooperate. Sorry? About 2 minutes. Debtors jail is a bad financial deal. The third point, debtors jail is a bad financial deal for Benton County's property owners. Even if you can get past the issue of whether we should really try to extract large sums of money from the county's poorest citizens, even if they're felons and misdemeanors, even if you say, yes, soak those defendants for all they're worth and then lock them up if they don't pay, debtors prison is still not worth all the trouble from a financial perspective. Here's why. Some people are going to pay their fines anyway with no coercion. That means there's always going to be a baseline amount of fines revenues in any county. But Benton has put together a debtors prison apparatus to collect an even higher level of revenue. That apparatus means higher costs are incurred in the courts themselves, in law enforcement, and in the jail in order to squeeze out a little more revenue. And the county can get a little more revenue because we know that people, even the poor, will pay whatever extra they can to stay out of jail as long as they can. To squeeze one more dollar out of this class of indigent defendants, I estimate that we property owners pay $3. There is little blood in that turnip. Looking at this issue another way, we property owners pay at least twice. We pay once when a real crime may have been committed to have a person go through the county criminal justice system. And then we pay again for the same process because of unpaid fines. Sometimes we pay again and again. It's not worth it. We have work crew as an alternative, and that's cheaper. These practices make money for the county. We're collecting money for victims' restitution, and that gives us the moral high ground as we incarcerate these people. So 3 points. Debtors prison affects mostly the county's poor and keeps them poor. Debtors prison violates defendants' rights. Debtors prison is a bad deal for county property owners. Thank you.
If you wouldn't mind just staying there with yourself. We've never had an opponent so deftly debate themselves. Now it's time to look into this issue in more detail with questions from our members. Here are the guidelines. Only Badger Club members may ask questions of our speaker. You will recognize them by their name badge, and please note that if it is possible to become an instant member if you have a cash or check available when we call on you. And we have folks that will sign you up in the moment. Questions are limited to 1 minute, less if possible. It should be framed as a question, not an opinion with a disguised question attached to it. Answers are limited to 2 minutes and will be carefully timed. D. Please let me reiterate, if you try to give a speech instead of asking a question, we will need to cut you off and move on to the next person. Please raise your hand, and we've got 2 people in the audience that will come around with a microphone. They will hold the mic and help you to speak into it. And as I have a microphone myself, I will ask Dee the first question. Dee, if financial legal obligations and court fines are eliminated, what recourse would judges have to recoup the costs of prosecuting poor people in our justice system? And what alternative form of judicial discipline would you suggest judges apply to soft criminal activities that don't warrant jail time?
First of all, they would have lower costs to recoup if they do what I would like. And the net cost of the taxpayers would be much less. So in terms of recommendations for alternatives to debtors prison, I have a bunch. So I'll just take a minute or so and give you a few. Reward pro-social behaviors like getting and keeping employment, getting mental health care, getting addiction treatment, education and training, regaining child custody. Prioritize collection and distribution of victim restitution payments. More to say about that later. Waive fines and fees and court costs, and you can do that legally. Tailor them for indigents and tailor them to people's ability to pay. Use work crew on weekends. Stop charging $5 a day for work crew. Send warning notices to people who haven't made payments. I'll stop.
Okay, thank you. So there will be questions from our members now and folks that want to become members.
Jim Robles from Walla Walla. I see you have Alice Hoffman's, I think, excellent book on the table there. And my question is, to what extent do you think our willingness to support these kinds of practices is lack of contact with the people who are in the system? I myself don't know anyone who's poor. Would we feel differently if we'd seen these human beings up close?
So thank you. This is the daughter. It's a book by the daughter of the famous sociologist Irving Goffman. It's a great book. It tells you about what life is like for people who are living under the threat of fines. It's a great book. On the Run by Alice Goffman. If you knew these people up close, you'd be struck by how much like you and me they are. But they have many, many deficits as well. And those deficits don't get overcome when they're incarcerated. Did I answer your question?
Part of the question was, would most of us in the audience feel differently if we had more contact with these people?
I don't know. I see people have different reactions to defendants, really. Some people have compassion, and others have more judgment.
Question over here.
Ginger Vetrano. Since I don't see an opponent, I don't know if they're too embarrassed to come because they feel that they can really support it. But what can we do to change things if we think this needs to be changed? What's the solution?
Ginger, I wish I knew. I have some ideas. The cities pay about 2/3 of the district court costs, so get your city council to stop sending money to the county for district court. That's one thing. Tell your county commissioner to stop approving budgets that include money for debtors prison. I think some kind of citizens commission is necessary to provide the courts input and advice about dealing with defendants who don't pay their fines. But it's a complicated issue. Go ahead.
There was a case recently in Montgomery, Alabama, where Southern Poverty Law Center sued because someone was jailed under these kinds of conditions. If Benton is the only county doing this, or his most egregious one, is it going to take some kind of suit, say, against the county to change it, to force them to make to come into compliance with what you describe as the requirements of the state Supreme Court?
Thank you, Nancy. I hope it doesn't take a lawsuit. I think if there were a lawsuit, it would cost the taxpayers a lot of money to defend that suit, and I don't want to pay for that. The cities would have to, Richland, Kennewick, West Richland, Prosser would have to agree to pay. It'd be interesting to see the city councils deal with that issue. I'm hoping that taxpayer outrage will just get it changed. Does that answer your question?
Is it not a fact that the judges are not permitted to assess financial obligations in determining ability to pay, they cannot factor in federal funds or state welfare money. If the patient or the person is on either SSI, SSDI, or one of the state welfare programs, is it not against the state law in that determination to use those funds as a means of paying fines?
Did everybody hear the question? Can disability payments be used to pay fines? So I'm not an attorney. That's probably pretty clear. I have read case law, federal regulations that say it's not permissible to use disability payments to make somebody pay fines. And I've heard more than one attorney say that it's illegal, but I can't answer that question with 100% confidence. I do know that there are people on disability payments, SSI and SSD, of about 9,000 a year, and the court's requiring them to pay fines.
Yeah, Jack Baker, thank you for your service and your thoughts. It's a great problem that we're having. It certainly causes us to think. You had your suggestions on what things could be done. Are there examples of other counties in Washington or locally where they've implemented your suggestions? And what are the results in terms of the cost of the judicial system and maybe the crime rates?
Thank you for that question. That's the $64 question, I think. Most counties in Washington send unpaid fines to collection agencies. And so when they go to collection agencies, the contracts allow the collection agencies just to accelerate the fines balances. And so people lose, they're in debt their whole lives and they lose credit and so forth. So, but that's not a whole lot different from what Superior Court here does. So I don't really recommend that as a full-scale alternative. It can be used sometimes, I think, sending fines to collection agencies. I think rewarding pro-social behaviors, I think having some form of community service would be a good idea. I think expanding the use of work crew, which is cheaper than incarceration in the jail, is still custody. But expanding the use of work crew would be a good idea, but there's some problems with work crew I'll be glad to discuss later.
Question over here.
Claudia Rumsauce. My question is, if Benton County is the only county in the state, is that correct, that goes by this process, where is the state Supreme Court on this issue?
I know enough about that to be dangerous. I know this is a state, several attorneys have told me this is a state where the state Supreme Court doesn't have a lot of power over the activities of local county courts. So I know that there are cases in the last several years, since 2011, where the Supreme Court has ruled against counties who do this kind of, who have practices similar to this. That's all I can really say.
Kirk Williamson, I'm going to try to do what you did probably better than I will, which is take the other side for a moment. What about the notion that there has to be some impediment to people who drive without insurance, for example? I was hit not too long ago by an uninsured driver. Yep. What about creating some sort of punishment for people who drive without a driver's license or do a number of other things that violate the law and have to have some sort of impediment, otherwise they laugh at it. And people who are maybe in the next social strata up say, well, if they're getting away with it, why can't I?
I agree. I think people should be held accountable, rich or poor, for their crimes. I think that Incarceration for short periods can be effective, is used in a suite of other responses to especially misdemeanor crime. We know statistically that incarceration for long periods of time, like we do in this county, has reverse effects. People become more hardened. But people should be held accountable in some way, yes. I'm not advocating that at all, that we ignore what they do.
There's a question here. Question.
Andy Perdue, you said that voter outrage is needed to change this. Aside from torches and pitchforks, do you have suggestions on how we go forward in trying to convince Benton County to reverse its position on this?
The commissioners are developing a budget right now for fiscal years 2015 and 16. So are the cities.
Question over here.
Claude Oliver. Know most of you in the room. The issues with regards to alternative sentencing and other factors that come into play, I think are particularly important in a new budgeting cycle with $9.3 million a year, new dollars above and beyond what has been spent in the past. Are there any levels being developed for youth at risk, communities and programs in the community? Are there any monies that are going to come into play with regards to paying to get people into diversion programs, rehabilitation, other drug programs? You know, it'd be a lot cheaper if we can keep them out of the system and keep them productive with a job, rather than put them in the system that they can't get out of or have a great deal of difficulty getting out of.
Claude, my boss, the person who's my boss at DOE when I was a budget analyst is here, and I haven't done that kind of work since she was my boss. So I don't know the answer. I don't know the answer to those financial kinds of questions, but it is, the solutions are partly financial in budget. Yeah.
Brett Menaker. I'm a little bit confused. Are the courts funded by the fees and the fines charged to defendants, or are they funded by the taxpayers as a whole?
It's a good question. So revenues from whatever source are budgeted separately from county expenses, right? So district court and superior court, for example, they submit a budget to the commissioners, and that budget is without revenues. But informally, the courts are able to point to their level of revenues as a way of showing the commissioners that their costs are being managed. And so that's misleading overall. Overall the costs are much higher. Costs for debtors prison are much higher than budget politics would have you think. Right? And that doesn't show in the court's budgets. There are jail costs or law enforcement costs that don't show.
I think we have time for one last question. There's a question here, question there. Two last questions. We'll do with two more.
I was just wondering.
Well, hold on, ma'am, just a second. He's got the mic. Somebody will come to you.
Bob Pearson, are you saying that two of the three county commissioners have changed their position on this issue, could change the policy? Is that what you're saying?
I think so. Yes. I heard a judge tell the county commissioners, "We will do what you want." It's systemic. It's not just the courts.
Question here.
Anna Bope. And I'm just wondering, is there a cap on how many times a person can be re-jailed because of lack of paying their fines?
For felony fines in Superior Court, no, there's not a cap. For misdemeanor fines in District Court, there is a cap. You get released when your fines go to zero at $50 a day.
So it could go on forever.
It's a lifetime. I know many people who owe, a lot in Superior Court. Yeah.
Thank you for your questions, your thoughtful questions. We will now give Dee a couple of minutes to wrap up his final thoughts and presentation. And let me ask our Digger Award Committee to start caucusing now so that we can present the Digger Award for today's best question. So Dee, you have a couple of minutes just to kind of summarize.
I'll be quick for once.
You're good.
3 things. Debtors prison affects mostly the poor and keeps them poor, helps keep them poor. Second, debtors prison violates defendants' rights. Third, read the 14th Amendment to the Constitution. Third, debtors prison is a bad financial deal for county property owners. Thank you.
Please join me in thanking Dee Willis for his excellent and enlightening presentation.